you actually have books that are different from this book right here. This is an undergraduate book right here. But most law school courses are taught from textbooks that are almost like treatises. These are kind of books that have a compilation of case books or of cases that teach or go over that particular subject. And in order to learn the subject, you're taught to actually go in and brief the cases. Briefing the cases is an exercise that allows you to actually learn the history of that particular legal development, of the development of that particular legal subject. And so, for example, in the subject that we are dealing with both today and last week, that is the definition of a contract, we would be going into cases that actually demonstrate the interpretation of the law that is governed or that governs contracts. So we'll talk a little bit, just briefly skim it today, but starting next class, you all will have to we'll go into a little bit more detail about how to brief the case and actually go into briefings of cases. And by the following class, when we start the consideration, you guys will be called upon, when I call upon you to talk about a particular contract issue, so one or more of you will be asked to help to brief various cases. All right? So that's something to just be aware of. So for today, let's start with Mr. Hassan. Mr. Hassan, can you tell me again, and we're going to go back to the last class in order to come to this class, and we're going to talk about again what is, and it goes to the homework that was sent out. And again, everybody got the notice of the homework. The homework, if you didn't get it in, normally homework will be due by the beginning of class. Just in case, there was some people who didn't get it, I decided to post the homework and making it due by the end of today. All right? So you have until the end of the day to get your homework in. Yes, ma'am.
Where did you post it?
I posted in the announcement. Oh, no, not the announcement, but in the homework category. So if you look under the homeworks, those are posted. Generally, you'll get an announcement as well, but the announcement didn't go out. So again, that's another reason why I'm giving additional time. All right?
It's under assessment.
Under assessments and tests, exactly. All right. So again, going to the first question is again define for me, Mr. Hassan. What is a contract?
A contract is an agreement that will be enforced by the court.
What are the elements of the contract that we talked about? What?
Stage 1.
Thank you. Mr. Calloway, elements of a contract? Mr. Calloway's not here. All right. Mr. Copeland, elements of a contract? That was in the homework, Mr. Copeland. Elements of contract? You know? No? Okay, well, why are you sitting down? All right. Next we have Ms. Green. Elements of a contract.
Offer, acceptance, and consideration.
Offer, acceptance, and consideration. Now, what are the other elements in terms of we went over also? I'll let you guys sit down since you get to that point. Go ahead. Miss Kayla Hall here?
Yes.
Miss Kayla Hall, tell me, and you were late. So, what time did you get here, Miss Hall?
8:15.
At 8:15. Okay. So we'll give you. Now, if you got here, what I'm going
start doing is I'm going to go over the attendance twice, generally. Once is for the extra credit points, and the other is for regular attendance. All right. So that's Miss Kayla Hall, right?
Yeah.
Okay. So going back here, is there anybody else here who just came in? Who's that? Who? Anybody else?
Justice Mary.
Okay, so again, we're going to give you guys a pass today, but normally we will have attendance. Yes?
I was here at 8:10.
Who's that?
Austin Parks.
Mr. Parks. Yeah. Again, we'll do that attendance twice. Once beginning in class and other at 8:15, and those who are there at the beginning will get the credit for being on time. All right. So again, going back to you now, Miss Hall. Tell me in terms of a valid contract. What is a valid contract, first of all? What is a valid contract? Now, again, some of the information was given in the last question, but there's something else that's missing.
A valid contract may be something that both parties have to be in agreement with.
There are five elements of a valid contract. 5 elements of a valid contract as articulated on page 231 of chapter 11. 5 elements. And one of the elements given, they combine 2 elements by this word agreement. Again, and I said the agreement really is synonymous in the legal context with contract itself, but this book uses it in a different context. But nevertheless, I'm asking you, Ms. Hall, and I guess you don't have it, so we'll go into Ms. Cindy Hall. Cindy Hall. Cindy Hall.
Yeah.
Elements of a valid contract. Again, Ms. Green gave you 3 of them. So what are they?
825.
Thank you.
Agreement.
Excuse me. Agreement is consists of what?
Include an offer and acceptance.
Offer and acceptance. So I don't want anybody ever to say that again. Don't say that. We just said it, right? Agreement is generally considered, again, a synonym. Synonym means what? The same as, right? A word equivalent to contract, right? That's generally what is considered, all right? So, but the elements of an agreement, the elements of a contract are 5, right? The first being what? Offer. Second being what? Acceptance. Third being what? Consideration. Fourth being what?
Contractual capacity.
Capacity.
And then legal.
And then fifth being what?
Legality.
Legal purpose. Those are 5 elements of a valid contract. So you have a valid contract, and let's go and talk about the 3 types of valid contract. 3 types of valid contract. Now again, we talked about, going back to legal capacity, we talked about legal capacity in the last class. We also talked about the offer, and we also talked about the offer. What we're going to talk about today, again, we're going to double down in terms of this, in terms of the how an offer, what consists of an offer. So and then we'll talk a little bit about the same with those other elements today. So that's, again, we skimmed it last class, but today we're going to go into the weeds. All right? So let's go into this issue of what are the requirements of an offer. Requirements of offer, and that will be requirements of an offer. That's Miss Hodge. Miss Hodge here. She doesn't appear to be on a roll anymore. Mr. Jose. Jose was not on a roll. Well, he was on a roll. He was not here. Okay, Miss King, tell me if you would, again, about this issue of an offer. What are the requirements of an offer? 3 requirements of an offer. Requirements of an offer as defined in the book, page 240.
The offer must have a serious intention to become valid.
Exactly. Intention. Second. No, I said
Oh, the terms of the offer must be legally certain or definite so that
definite terms. Third,
must be communicated.
communicate. Those are the requirements for an offer to be considered as a valid offer. All right. So when we talk about, thank you, Miss King. Yes.
What was the first one after the definite terms?
Ms. King, repeat that for your classmate.
The first one. Intention.
It's 8/3.
Thank you, sir. That was Ms. King. Okay. So, in terms of intentions, Mr. Karoma, how do you determine a person's intention? Mr. Karoma, how do you determine a person's intent?
You find value in the contract.
Is the person's intent determined by his or her subjective intentions and beliefs and assumptions of the offer, or
Or
what determines a person's intentions?
the subjects of the contract.
Pardon me?
The subjects of the contract determines the person's intentions. Intents.
What was the basis of that answer, sir?
What are the intents of the contract? What was your question again, sir?
I said, how do you
what are the requirements of an offer? We talked about the requirements of an offer. Then I asked you then, how do you determine a person's, how do you determine a person's intention? Is it determined by their own subjective behavior? Is it determined by the assumptions or the beliefs of that particular offer? Or no?
It's determined by the reasonable person within the offer.
Right. It's determined by what a reasonable person in the offeree's position would conclude that the offerer's words and actions meant. So it's, again, the offeror is who, Mr. Karama?
The person who is giving the contract.
The person who's making the offer.
That's
The
right.
contract,
Making
right?
the offer. Correct.
Exactly.
Yes, sir.
The person, so again, is it determined by the offer, is the intention to make an offer determined by that person?
No, it's
Determined by the person
offer.
receiving.
Yes, sir.
Receiving, right?
Yes, sir.
Person, if they would conclude, the person who has the power to accept, right, would conclude that an offer has been made, right? And so, again, there's an example in example 12.1, which is our first example on this particular subject, and I'll ask you to go into that. In fact, I'll quickly go over to it. In this instance, and you can have a seat, Mr. Carroll, you have Linda and Dina. They ride to school each day in Dina's new automobile, which has a market value of $20,000. However, one cold morning, they get into the car, but the car will not start. Dina yells in anger, "I'll sell this car to anyone for $500. Linda drops $500 on Dina's lap. A reasonable person taking into consideration Dina's frustration and obvious difference in value between the market value of the car and the proposed purchase price would realize that Dina's offer was not made with serious and objective intent. And so therefore, no offer was made. All right? And thus, there was no what?
Agreement.
No agreement, no contract, all right? So again, what you have to do is not necessarily listen to the person's words, right? But to think about, well, what is reasonable? What's reasonable? And that's, again, why the issues of cases, such as the one that we just discussed in example 12.1, are important, because cases determine what is reasonable. What has happened in the past determines what a person should be considered, what should be considered as a reasonable offer or not, all right? So that's what we talked about in terms of when intentions. So again, what are situations when intent may be lacking? There are about 1, 2, 3, 4, 5, 6, 7, 8, 9, about 9 cases in which, or 9 situations in which statements are not offers. All right, let's ask you, Miss Murray. Miss Murray, are you here? Okay, you get your points since you're here.
It's 8:35.
Thank you. Mr. Muslim, 9 situations in which an offer is not actually an offer at all.
Expressions of opinion, statements of future intent.
Expressions of opinion. So, example. So I want you to tell me what it is and give me an example.
Okay, an expression of opinion is not an offer. It is not.
Hold on. I don't want you to read it to me. I want you to give me an example, sir. Give me an example of an offer that is actually an expression of opinion. And they give you some case examples here. So you can go straight there. I don't want you to read it to me.
Took his son to McGee, a
Physician.
physician, and asked McGee to operate on the son's hand. McGee said that the boy would be in the hospital 3 or 4 days, that the hand would probably heal a few days later. The son's hand is not healed for a month, but the father did not win a suit for breach of contract.
Because of what? Because,
the son's hand didn't heal.
again, and the son's hand didn't heal, so that was his injury. But so he sued the person because he said the hand didn't heal within the time. Right, but was that
was that an actual offer that was made?
No,
Because it was only what?
it's like an opinion.
It was an opinion. Said, I think it's going to heal in that time, right? And opinions cannot be made, cannot be offers. Next, what's the next one, Mr. What's the other?
Statements of future intent.
And again, I don't want you to read me the thing. I want you to tell me, give me an example, quickly to summarize.
Smith says I plan my stock in Innovation Inc. for 150 per share. If John accepts and intends the 150 per share for the stock, no contract is created.
Because of what? What word did he say?
Accepts.
No. What word did Samir say?
Plan.
Plan. That means what?
Future.
Not now, right? But in the future. Again, very important. You guys are going to need to know this, right? And not just on the test, but you need to know this in practical life. All right? Somebody says, okay, I plan to sell my Mercedes-Benz for that costs $100,000, but I plan to sell it for $20. You throw $20 on there. You say, well, no, I would say I plan to, and I plan to when I can no longer drive it, So again, there's no offer. All right. Next, Mr. Muslim.
Preliminary negotiations.
So give me an example.
When you sell the estate, or I wouldn't sell my car for less than $5,000. For example.
So again, when you're in an idea, when somebody is sitting down, you're talking about, will you do this if I do this, right? So if a person is say, I'm going to do this, but I'm asking, will you do this, right? Is it possible that we can have a contract, right? If those words are expressed, then there's no offer, right? Offer is, again, definite, so it says, I will do this, not would you or could you, okay? Or will you, right? No questions. Okay, next, Mr. Muslim.
Advertisements.
Okay, such as what?
An advertisement on the ScienceNet website asks readers to submit new tips, which the organization would investigate for possible inclusion in its magazine on the website. Third trail,
Again, summarizing. So again, if somebody said, if you put on an ad, I'm going to give you, $100 for if you can bring me, a pair of new Nike cleats, right? You did an ad, $100 if you can give me new Nike cleats. And then the person says, I'm going to do that. I'm going to bring you the Nike cleats. The question is would that be a offer? And Mr. Muslim, what's the answer?
said would it be an offer? I didn't hear what you said.
Would that be an offer by saying, I'm going to give you $100 and bring you new Nike cleats?
Say 40.
Thank you. Because the reason why the court dismissed, the court said no, because the ad was not an offer, but merely an invitation to offer. Responses to the ad were not acceptances. So therefore, again, the submission of the manuscript, the submission of the cleats, so bringing the cleats is the offer. That's the offer. The advertisement is an advertisement for a person to offer. So that's what you have to understand, okay? So again, a price list is another form of invitation. So just again, if I put out, if I have a list of books, right? So I'm selling this book for 10, this one for 20, this one for 30, right? And somebody says, okay, cool, I'm here to buy that $30 book. I can say, well, no, I'm actually going to sell it for 50. He said, well, no, you got it right here. It says you're going to sell it for 30. And I'm going to say, well, no. Again, the fact is that I'm only advertising my my interest in you offering, right, to buy something. I'm advertising my intention for you to offer me. So that's not, again, considered a valid offer because the intent is lacking. Next,
So, Professor,
yes.
so when do like the limits of advertising? Because you can advertise, you can say anything, and then you can turn it and be like it's an advertisement.
Exactly. That's it. That's the thing. That's the thing. You have to, again, now some people in business will honor, right, their advertisement, right? But that's not required. It's not required. All right? That's what you have to understand. Okay? Yes.
False advertising, what could be still on?
False advertising is another element that you can bring up and say, hey, you know, you advertise this, but you did not honor your didn't honor your advertised price. However, false advertisement is not considered is not the same in every state. All right, and false advertising, there are also false advertisement laws that are federal and not state laws. But generally, again, an advertisement is not an offer. All right. Another thing is, again, Mr. Muslim, another example.
Online auction. It's like
Online auction. So you don't have to give me the examples, but I want everybody to take a look at what the examples are. What's next?
live auction.
Live auction. So again, you have both online auctions and live auctions. The difference is, though, it's like advertisements and price lists. Offers to sell an item on these sites are generally treated as invitations to negotiate. However, in the context of a live auction, right, a seller offers goods for sale through an auctioneer. This is not an offer to form a contract, rather it's an invitation asking for bidders to submit. However, in the context of the auction, a bidder is the offerer, and the auctioneer is the offeree. The offer is accepted when the auctioneer strikes the hammer. Before the fall of a hammer, a bidder may take back his offer. All right. When the auctioneer accepts the higher bid, he or she will reject all the other previous bids. So again, when the offer or the person selling it gives it to the auctioneer he's transferred his ability to accept the offer from himself to some third party. All right, so that's kind of a difference between online auctions, when generally the person will retain the ability to accept, and a live auction when the person is transferred to a third party. All right. Another thing is auctions with and without reserve. So again, in an auction situation, Mr. Muslim, we're not done. In an auction situation, you have you have some auctions that are called with reserve or without reserve. So in the context of a auction with reserve, what's the difference, Mr. Muslim?
Reserve is the seller.
Pardon me?
In the auction with reserve, the seller may withdraw the goods at any time.
Exactly.
Say 45.
Thank you. Without reserve means what? Without reserve means what?
The goods cannot be withdrawn.
Exactly. So again, once that has been given without reserve, then again, whatever comes in, even if it's not, again, something that is reasonable, that person has no ability to say, no, I don't want to sell it. All right. In the context with reserve, the person may withdraw or reject the sale even after the hammer has fallen. Okay. But again, in those contexts, if you're going to do it without reserve, or with reserve rather, and the ability to withdraw, generally you'll have to notify everybody in that auction that if the money doesn't reach a certain threshold, then the person can withdraw that that item even after the person says sold. Even after the auctioneer says sold, the power to withdraw that is in place if you said that this is an auction with reserve. All
All right. Next is the and again, you can have a seat, but you can have a seat. There are two other instances. One is an agreement to agree, and this is a case the person says, "I'll agree to agree," generally in a future date, and that's not a offer either. And then in the other instance, it says, "Well, I will preliminarily, give you this." So again, when somebody says preliminarily, that means that again it's not definite. So these are the things that you need to understand. Also need to understand the definiteness of the terms, and you also need to understand again the issue of whether or not it's been communicated. Now, in the context of communication, let me ask you, Mr. Parks. Mr. Parks, how do you communicate the offer? How do you communicate? Give me an example of communication with offers.
Telling the offeree what you want from them and what you're going to give to them.
So, can a person, if a person does something, but he doesn't know that you have basically offered to contract with that person if he did that, is there, let's say for example, if you say, I'm going to give a reward to anybody who finds my cat, and somebody not knowing of the reward finds your cat and turns it in, and then somebody later says, "Oh, well, this person was going to, give anybody who found his cat $1,000. Go back and get your $1,000." Can you go back and get that $1,000 and say, "Hey, well, you agreed to give anybody who found the cat $1,000. You didn't give me my $1,000. Can you go back and get that $1,000?"
I'm gonna take a guess. So basically,
No, don't take a guess. Do you know?
I mean, given what we've learned so far, I think I do.
Okay, then what is it?
I think that
Quickly, sir. We only have a minute left in class.
I think no, because with the offer and acceptance, that's to it's communication on both sides, and for the other person to not know, that means it wasn't communicated to them.
Exactly. No communication. So again, only a few states allow recovery of the award, but not on contract principle. But instead, they can award a recovery on the basis that it would be unjust or unfair to deny the reward just because he didn't know. All right. So again, generally, the offer has to be communicated. All right. Thank you. So again, it's a 50-minute class, right? So again, what you all we'll go into more detail in the next class. We'll go into the issue of termination of the offer by law. We'll go into more details about the acceptance as well, and the issues of unenforceable agreements, right? Particularly in the context of electronic contracts. All right. Again, reading is important, as you can see. It's important for you to come prepared in order to make sure that you get the points. Now, I will, for people who, for example, did not get, we didn't get a chance to come around to you when you were here, such as, you get points for helping me today. Mr. Edwards. Is that Mr. Edwards? Give you.
I don't think that door gonna go.
We don't get a chance to get you. Go ahead and get you points.
So it was people that were trying to join, but I don't think they're in the class.
It's no problem.
Okay.
Yes, sir. Oh, you're still live.